Good afternoon and welcome. I'm Dr. Liesl Bryant, one of the risk management consultants for the American Insurance Trust, known to most of you as simply the Trust. And we are delighted that you're able to join us for this next webinar in our virtual webinar series. As a trust policyholder, most of you are likely familiar with the Trust's risk management consultation service, or the Advocate 800 program. It's one of many benefits insureds receive through the Trust. I am one of the 8 advocates, and I am joined today by 2 other advocates, Drs. Joe Scropo and Jeff Youngren. So I hope you both enjoy and benefit from our roundtable today, and please join me in welcoming Drs. Scropo and Youngren. Hello, Joe and Jeff, welcome.
Hi, Guy. Hello.
So as usual, we will start with a couple of the questions that we have already prepared that come from many of the questions we got from insureds. So we'll begin with those. We have 2 questions for both of you today, and then we will dive into the questions that come up on Q&A, the live questions. So, and you in the audience can feel free to at any point go ahead and type in the questions in the Q&A box, and we will get to those as soon as we can. All right, so that being said, Joe, I'm going to start with you. And as you know, we get a lot of questions about types of business structures. So for instance, solo proprietorship versus an LLC or some type of a corporation. Can you walk us through some of the pros and cons of the various structures and provide some tips for clinicians to think about, like, what to consider when they're trying to make the decision as to what business structure they should have?
Sure. Okay, so there are a few different kinds of business structures that are available to licensed professionals. The default structure, if you don't do anything, is a sole proprietorship. And that's where you're the sole owner and you don't have to file any paperwork with the government. You run your business and you're the only one in charge. The next group of business structures would be partnerships, general partnerships, and then beyond that would be professional corporations and limited liability companies. So sole proprietorship is the default, and these are the other structures would require you to register with the state and engage in some formalities that accompany any formal business structure. So those are the choices, and those choices may or may not be available to you in your state. Some states don't allow licensed professionals to form, for example, a professional corporation an LLC, and require that licensed professionals form a professional corporation. So what I'm saying is general. It depends on your particular state as to what choices are available to you. Now, one of the main reason, or often the reason I get calls about, should I incorporate, should I set up a formal business structure, is will that protect me from malpractice suits or board complaints? So the very first thing to know is that neither the sole proprietorship nor any of the formal business structures will protect you from malpractice suits or board complaints. You're always going to be vulnerable to those kinds of adverse actions, and no business structure will shield you from them. But the formal business structures, the ones that are the LLCs, the professional corporations, and the limited liability partnerships, do create a kind of barrier between your personal assets and the business's assets. So once you've created one of those formal business structures, you're hopefully going to be shielding your personal assets from any successful judgments or creditors who come against your company or corporation. So that's the value of creating these, but it will not protect you from malpractice actions. The kinds of things that it will protect you from, for example, are contractual issues. So if you have an LLC or a professional corporation, you enter into a lease with a landlord, You sign the lease in the name of your PC or LLC. And let's say, unfortunately, you default on that lease and the landlord has a cause of action against you. The landlord, if they successfully sue you, can only collect from the assets of your formal business, the PC, the LLC, or the limited liability partnership. So that it will protect you against that. And that's not a meaningless protection. Businesses take out credit cards, they take out lines of credit. And if you take them out in the names of the formal business structures, you'll be protected in the event you default on those lines of credit or other contractual matters that you created for the business. So that's one basic consideration. The downside of creating a formal business structure is that it's going to take some money to create. Typically, you're going to need to consult with a tax advisor and a legal advisor to form the right structure for you. So there's a cost, and every formal business entity requires certain formalities, business meetings, minutes, other kinds of formal acts that have to be done through the year. And if you don't do those, you will lose the protection of the corporate shield that you created to begin with. So there's an investment in money and time, and so you want to balance that against the potential benefits. The benefits, as I said, are primarily against actions, non-malpractice actions brought against the company. Another value of the formal structure is that if you have partners, it will protect you against judgments or collections made against them. The default rule is that a partnership without any limited liability component makes each partner liable for the acts and omissions of the other partners. So that if your partner has a malpractice judgment against them, they didn't pay their professional liability insurance, they're facing a $500,000 judgment. The judgment holder can take that money from you or any other general partner. So the formal business structures protect you from your partner's errors and omissions, which is another value in doing this. Maybe less important values of the formal structure is that it helps you to organize your finances so that you have a checkbook and a business account and you have your own personal account, and it helps you kind of keep those things separate, and which can be very helpful at tax time and kind of knowing where you're at in terms of your business finances and your personal finances. I've said this before, but in order to maintain the protection, it's important that you honor the formalities of your formal business structure. And that means displaying on official letterhead or any kind of document or material that you generate from your corporation or company, the PLLC or the PC, which stands for professional corporation or limited liability company. You need to always do that so that your clients and customers and other folks you deal with know that you are incorporated. They have to be on notice for that. And you have to be careful about commingling money or using the corporate shield as a way to kind of do shady things like hide your assets and things like that. So with that said, you would balance the kind of the pros and cons. And if you do decide to go ahead, it's important that you do it with consultation of a tax advisor and a lawyer as well.
Great, thank you, Joe. You fit a lot of really great information in there. Jeff, anything you want to add to that?
Yeah, I think it's important for people to carefully analyze, as Joe's alluded to, the cost-benefit nature of making that decision. You will be loading yourself up with a separate accounting process. You're going to be loading yourself up with the various activities to fulfill the requirement of the law. So you have, I think people who are considering incorporating need to ask themselves a question of why they're incorporating. And that's where the consultation is important, I think. And if it's just that you want to not take any risk in terms of malpractice, it's much cheaper to buy more malpractice insurance and coverage than it is to set up this structure to accomplish that. The last point is that this is not a place you can hide assets. People think that they can do that, and as Joe has said, the tax rate may be less for the corporation, but of course, if you default and somebody comes after you, those are the assets they can go after, and you can't just move them to your private account when that occurs. That actually is a crime. So this is a rather complex decision that individual psychologists need to make.
Yeah, I agree. Thanks, Jeff. And there may be too some differences in terms of your judgment on this, whether if you're a sole person in the practice versus if you have multiple partners, like Joe mentioned, or employees. That is going to maybe make a difference too in terms of whether there's significant benefit for you or not. So really important to do that. And I will say too, because I have a lot of people sometimes have called and said, oh, well, you know, my other friends here, my other colleagues have all incorporated. I need to do that. And that's not always the case. So I agree with both of you that you want to make that individual determination based on your own needs. And ideally, as Joe said, in consultation with an attorney and accountant. So
yeah, you don't really know why those people incorporated. They may have different reasons than you have.
Mm-hmm. Right. Right. Okay, so Jeff, we'll give the second question to you. And I know this is related to licensing boards. And you have often said that the licensing board is not a friend of psychologists, or not our friend as psychologists. So can you tell us a little bit about what the purpose of the licensing board is, and why sometimes you say that it may not necessarily be a psychologist's friend?
Sure, it's a very important point that licensing boards regulate the profession. So there are benefits to being a licensed profession for sure, but a licensing board has an obligation to the public to regulate the profession in the best interests of the public. And so while people on the licensing board may be your friends, as a group, their obligation is to operate in the best interests of the consumer. And so they regulate you. And so if you are in a situation where you are confronting and dealing with a licensing board, that frequently is an adversarial situation. They put out regulations, they put out requirements in the spirit of offering services to the consumer, but they also are going to hold you responsible for fulfilling those responsibilities. And so inquiries from a licensing board can be fairly problematic, and you need to be careful with that. It is important to stay current with the licensing board. It's important to go on the licensing board's website and read what they're doing. It's important for you to be, I think, a part of your state psychological association, not to give them revenues, but to use them as a source of information regarding what the licensing board is doing and what is being required of psychologists. Those guidelines and requirements are not things that are designed primarily to help you. They're to help the consumer. We frequently make the mistake of assuming that that is helping the profession along, and it's not.
Thank you, Jeff. Joe, anything you want to add?
Yeah, I'm often surprised when I speak with some callers that they don't go to the web page of their board, or they've never gone there, or they're not even sure what the name of the board is. Jeff's correct that they're not necessarily your friend, but in order to protect yourself, it's important to know what the rules are, what the advisories are that are put out by your board. Boards are frequently updating their rules. For example, with the onset of telehealth in the pandemic, many state boards all across the country have now formulated advisories that address telehealth, which is what they think we should be doing when we do telehealth in that particular state. Now, the advisories don't have the force of law or rule, but that is what the board thinks you should be doing, and that's not something to take lightly. So there's a real information benefit in going there, and some states have really neat pamphlets of all the relevant rules and laws that licensees need to know. And it's tremendously helpful to sit and just read through that. Hopefully it's not too long, but it will educate you tremendously and help you in your practice. So Jeff's correct that ultimately the board is not there for you, but they do provide plenty of material that you should use so that you don't end up in trouble with them.
Yeah, I think that's really important, Joe. And I think one of the things that our insureds need to pay attention to is the regulation of their licensing board as opposed to other licensing boards, because the boards have dealt with telehealth issues differently, as an example that you made. And so one of your friends who may be in New Jersey or in Oregon may tell you something that's specific to the regulations of New Jersey and Oregon, but you're in California, and the California board, as an active board, has their own position on things. So make sure that you're careful about the source of that information, and be very careful of hearsay. Our profession is full of people who love to give advice to their colleagues about how they should operate professionally with regard to legal regulation, and that's dangerous turf. I think Joe smiled there that you would agree that the hearsay problem is a big problem.
Yep, definitely.
Well, and I've had multiple calls just this week where there's clear misinformation that's being sent around on listservs and various things like that. So it's a really good point, Jeff. And I will say too, to your point, Joe, like a lot of the information on, say, temporary practice laws or advisories, like you say, Jeff, in certain states is on the website for various boards. And it's really helpful if you are going to be practicing into another jurisdiction. That's a source of really important information for you as well. So that, that's where you can find a lot of that information that you'll need to know about the other jurisdiction too. So.
Yeah, it's really just one last point is a good example of that is this new SIPAC model, which applies in some states and not others. Actually, SIPAC is a kind of a complex entity, and just getting yourself lined up with the requirements of your state SIPAC isn't quite the end of the road. You need to be very familiar with how that works and how it doesn't work.
Yeah, and with some of the rules and laws in other states that are not your home state.
Absolutely. I mean, we could go on for hours with that one.
Right, exactly. All right, we'll pause there unless there are questions that come up. So Joe, I'm going to turn it back to you for the next question. And I wonder if you can talk for a little bit about the doctrine of a parent partnership and what some of the risks are with that, and also what risk management strategies would you suggest folks utilize to manage some of the issues that arise?
Yeah, good question. This is a really important concept, and it's something that I get calls about fairly frequently. Just to lay the groundwork for what a parent partnership is. As I said a little bit earlier, partners share unlimited responsibility for each other's actions, for creditors, judgments, etc. So you do not want to be viewed as just a general partnership. Now, the doctrine of a parent partnership exists when people who are actually independent professionals kind of form these informal groups, people in their suites, maybe that they begin to kind of work together. They may create a web page for themselves as a group. They may have a business card that has the name that they've created for this informal sort of group of people, yet none of them have there's no formal business structure, and each is actually an independent professional. And this seems helpful and useful for many folks, and in many ways it is. You get to sort of talk with colleagues and do things together. The downside is the apparent partnership doctrine, which is that if a reasonable person would perceive that you and your group are holding yourselves out as a partnership, as a unit working together, the court will treat you as such. So that suddenly you may find yourself being subject to a collection action or a judgment being taken against you because your suite mate down the hall had an action against them. And the consumer, the service recipient, perceived reasonably that you were all together because there was many indicia of you actually appearing to be working together. So that's a very risky thing to do. And what you want to do to avoid it is there are multiple things. One is to put in your informed consent, and each of the people that you work with or in your informal group, each put in your informed consent, I am an independent practitioner. There are other people in the suite or other people that you may see in this office, but they are separate and I run my own business independently. Alternatively, or in addition, you might have signage in your office that indicates all the practitioners here are independent practitioners. They are not in business together. You want to avoid a common web page, a common name for your group. You want to avoid sharing expenses for, say, a secretary who's going to be helping everybody in the group. The more that you do these things, the more that there's a perception that you are a partnership. And again, that is something you really want to avoid. So just bear that in mind and be very careful. If you're not in a formal business structure with others, what you are is just like a professional and the other person is another professional across town. You may be literally the door right next to you, but for legal purposes and professional purposes, it's best to think of all your independent practitioners around you as being just totally separate practices. And thus you have to honor the formalities of informed consent or sort of authorizations if you're going to share information with the other folks. You need to maintain all those formalities to avoid this doctrine being applied to you.
Mm-hmm. Great, thank you, Joe. Jeff, any additions there?
Yeah, I think that the thing, Joe is absolutely right on with this. But the thing that I see the most common is that people will share a series of office suites and they will name it the office suites, the Razzle Dazzle Psychotherapy Center, and they're all working in it. And even though you might have your informed consent that says you're an independent practitioner, having that kind of a title for the group of individuals argues against the independent practice sole proprietor model. So people love those labels, but you need to be very careful about that. You can be the Razzle Dazzle Psychotherapy Center, but when you kind of wrap all of the practitioners in that, it looks like a group practice to me. And you have to really be very careful of that.
Yeah, that's great, Jeff. And just to be clear, someone asked the question, what this called. It's called the doctrine of apparent partnerships. So just to be clear. So Jeff, our last question before we move on to start taking some of the live questions, I'll send back to you related to licensing boards again. And the question is basically, what should a psychologist do when confronted with a licensing board complaint? And also, if you could speak briefly to what happens if that complaint process starts with an investigator showing up at a psychologist's office.
Sure. I mean, I think that this is a very dangerous turf. This is where I'll back into the first question, which is the board is not really your friend. And especially in the situation where an investigator shows up in your office and wants records or even has an authorization for records, whatever they want. You have a right to representation, and you can bet that the board has already taken whatever complaint they're dealing with and run it through their lawyers, and you are now in the world of administrative law, which requires that you have representation. there's no such thing as a legal emergency. So an investigator showing up in your office, and in some states, these investigators actually carry weapons. They are armed. So, I mean, that is hardly a friendly thing. It's adversarial from the get-go. And so, but you have rights, and you have a right to representation. You always have a right to representation. And so you don't want to get into a situation where you respond to that kind of pressure. You also will usually get an inquiry or board complaint through correspondence. And what that correspondence depends upon the state, but usually what it'll say is blah, blah, blah has happened. This is the allegation that was made by blah, blah. And you have 15 days to respond, or respond by 15 days from now, and it's already 5 days late. You don't have enough time, and you think that it's just psychologists who are asking for this information, but it's not. It's an adversarial proceeding, and they are gathering evidence, and you don't know how to respond, and you shouldn't respond. And those of you who have consulted with us know that the first thing we'll tell you is you send us that complaint, and we will help you find an attorney who knows what they're doing to help manage the relationship with the board. It is adversarial. There's, you know, and so we really don't want our insureds writing that response letter. You don't understand the legal implications of that. You can complicate your case significantly. And on occasion, and I think Joe would agree, and I've had it happen, people have actually made their case worse by making statements that they believe are in their best interest in this proceeding. So for me, you need an attorney. We'll pay for that attorney, and you do what that attorney says and let the attorney take the case. And the first thing the attorney will do is go to the licensing board and say, we need 30 more days. And they'll give it to them so that they can manage the case, because you can't just walk into an attorney's office and get representation. Many of these people are very busy. So this is very dangerous turf when this occurs. So that's enough.
Thanks, Jeff. Joe, anything you want to add?
Yeah, I mean, essentially what's missing in the board investigation process is your Miranda warnings. Criminals get the benefit, or potential criminals get the benefit of the Miranda warnings. You're going to need to assert those for yourself and to remind yourself of those. Anything you say once there's a board investigation pending can be used against you. Statements you make to colleagues, statements that you make to the patient who's complaining against you or their family members, all of the statements you make to the board, all of those can be used against you. So trained investigators they learn to ingratiate themselves because they know that's how you get information. So be respectful, be kind if you're encountering a board investigator, but have no hesitation to assert your right. That, you know, I'd rather speak after I talk to my lawyer, or I'd rather speak with my lawyer. So be ready to do that. And second, make sure that when you do get a lawyer, you get a lawyer who knows the boards. The board practice is a very unique and idiosyncratic area of law. And most attorneys have no clue about how to defend an action in front of a board. So you want to make sure you vet your attorney. If and when you come to have to defend yourself against a board complaint, make sure they've done this in front of the healthcare boards multiple times before you choose that attorney.
Yeah, that's good. Oh, go ahead, Jeff.
I was just going to say, and lawyering up is not an admission of guilt, and it doesn't look bad because the board has already lawyered up. You can rest assured of that. So this is just really prudent. You know, the bottom line, do not write those response letters yourself.
Right. Well, and as I've shared with you, Jeff, my sense, if people really, really want to write it, I often tell them, go ahead and draft your response letter, but don't give it to the board, give it to your attorney, right? Bullet point out your points if you really feel like you need to get it. And sometimes, of course, it is anxiety provoking. So I understand the desire to just like put some facts down on and sort of counteract the allegations. But yeah, I completely agree with you, Jeff. You don't want to send any information to the licensing board until you've first consulted with your attorney. And Joe, I appreciate your raising too the connection or the distinction between criminal law and administrative, because I think oftentimes sometimes clinicians assume that we have a lot of the same protections in a licensing board complaint that we would if there was a criminal case, but we don't. They're very different areas of law with very different, and so it can seem odd. So all the more reason, like you both are saying, to get an attorney, right? To not assume that you know the process.
Right.
Okay, anything you want to add, Joe, before we dive into the live questions?
No, let's dive in.
Okay, great. So here's the first one. It says, I work in a small private practice clinic. While all of my colleagues are vaccinated against COVID, our office manager, who greets clients and accepts payments from them, refuses to get the vaccine. What obligation do we have, if any, to inform clients about our office manager's vaccine status? And Joe, do you want to start with that?
Yeah. It depends on your state law, and some states are much more aggressive about giving employers rights to ask for and to request documentation of vaccination for their employees. So to some degree, this is state specific. There are some states that are working actively to prevent employers from having that. And the matter is being litigated at a federal level. President Biden passed a rule that required certain size companies to be able to mandate their employers get vaccinations. A federal judge blocked that. So it's a little bit of an unsettled area, but almost all healthcare settings are going to need to follow CDC guidance. And CDC guidance says in a healthcare setting, all persons, staff, clinicians, patients, everybody should be wearing a mask, regardless of vaccination status. And they need to be maintaining social distance and following other policies and rules. So the worst case scenario would be with this unvaccinated employee to require that they follow all the other procedures, to be masked, to maintain social distance, etc. And to be tested. Many states will allow periodic testing in lieu of the vaccination. So there are some fallback measures you can take to deal with an employee like that. And if you work in an at-will state, you're not required to have any reason to terminate an employee. So that could be a basis to terminate somebody.
Mm-hmm. Right. Jeff, any additions there? Or?
Yeah, I think that too often people think these things are black and white, and good and bad, and there's a lot of gray. So as Joe said, while you have an employee that is not vaccinated, there are many things you could do to reduce an argument that you were negligent in dealing with clients, informing them that there are people in the office that are not vaccinated, making people wear masks, following the CDC guidelines, so that if somebody alleged that you committed an act of malpractice by injuring them, that becomes argument of all the things you were doing on the positive side. And Joe is right. It's really, as everyone knows who reads the newspapers, it's a state-specific issue. This has become a political issue. And so you really need to be aware of what your state is saying you can and can't do.
Mm-hmm. Great, thanks. Hopefully this is a fairly quick one, but there's a note here that the trust does offer additional cyber insurance through Chubb. Is this advisable? Joe?
I'm not too familiar with the cyber policy, but the kinds of policies that are being marketed now to a lot of clinicians have to do with breaches that increasingly HHS, the entity that administers HIPAA, is being very, very aggressive about policing violations of the HIPAA security rule, which is the rule that pertains to electronic PHI. So PHI that you maintain on computers, any kind of digital format. There's a bunch of rules that the HIPAA security rule applies to those to that PHI, and breaches are now being pursued very aggressively by HHS. So cyber insurance, you need to find out what specifically is covered. But I would say that one of the most essential would be defense or coverage for a breach. That is, I think, the most common kind of issue that's likely would arise for psychologists. And it can be very devastating, and it's easy to do. You send an email out to a client, you type the wrong letter in the email address, and your sensitive communication to your patient goes to a complete stranger. You have a breach on your hands. The client whose information is affected may try to come after you for negligence for what you did. So if the cyber insurance covers that and related issues, it may be worth it. I think one way to gauge it would be how much you're using electronic transmission and electronic storage of EPHI. If you're doing a lot of that, I think it may be worth considering.
Mhm. Great, thanks. Okay, the next question has to do with Medicare. It says here that this clinician understands that Medicare, the national emergency may end on January 13th, 2022. So maybe, I think here they're just looking for some confirmation of that. And also then, will other insurances follow or not? And maybe some advice on how to handle that. Jeff, you want to start with that one?
Yeah, insurance companies are going to do what insurance companies do. So you need to make sure that you check with the various insurance companies to make sure that they are reimbursing and for what. Our biggest issue that comes up in this is interjurisdictional practice, is that somebody is providing service in another state. And there are some states that have emergency orders in place. Medicare exceptions and changes may actually end in January. Who knows, right? It's politically driven. But if you are going to assume that you can provide services and bill it, or provide services in another state and bill it, you need to check with the respective carriers, because they're different. And you may be thinking that it's fine to do something in Nebraska, but it's not okay to do it in California. So be very careful of that.
Yeah, and I'd add to that, Jeff, I think it's important too to know that there may be changes coming. I mean, I think it's reasonable to assume that. And so it's really important that you're notifying your clients of that now, right? And you don't know what the changes are, but making sure that clients know that that might happen, and having a bit of a game plan for how you're going to manage it, so that they don't get surprised if in January you have to transfer care or something like that. So just making sure they're aware. Joe,
yeah, the emergency orders may expire. Some have. I think Michigan's expired, and you just kind of are going on and seeing a student who now lives in Michigan under that order. Well, it's not allowing you to do that, and you're arguably in violation of the state licensing law then.
Right. Any additions, Joe?
Yeah, the public health emergency declaration exists at a federal level and then at state levels. So the federal health emergency has been in place since like March of 2020. And by rule, it lasts 90 days and then it's renewed. Or if there's a will to renew it, it's renewed. It's been renewed every 90 days. And the way things are going, it looks like it's probably going to be renewed again when it expired, the most recent one expires. But be aware that federal public health emergency only affects Medicare, Medicaid, and perhaps some HIPAA rules. Otherwise, the relevant state, the public health emergency is your state. Many states, almost all states, declared a public health emergency during the epidemic at its height, and that relaxed licensing rules and other insurance reimbursement rules and many rules that were that came along with the state's public health emergency. Once those expire, all those kinds of exceptions are going to vanish. So you need to keep an eye on your state's public health emergency and whether it has ended, in which case your state may have kind of gone back to where it was pre-pandemic, although many states have now used statutes to try to preserve and keep the changes that were made because they found out that they were helpful. That included liberalization of telehealth so that phone would be covered by insurance. Many states have now codified that into law. So you need to pay attention to both the federal public health emergency and your state's public health emergency.
Yeah, and I will say this is where I think one of you earlier mentioned SPTAs, the state psych associations. This is where many of the state associations have been getting information out to their members on this. So this is a great thing where, you know, a place where they may be able to provide more resources or knowledge about your specific state laws. And I also want to note, so the same person who asked the question wrote in with a clarification. I think this was their real point. So does the emergency ending in January 2022, if in fact it ends, if it's not renewed, does that mean that Medicare will no longer reimburse telehealth either via video or phone after that date?
I understand.
I don't think that's what it means.
Oh,
Joe, you know this better than I do. Go ahead.
Well, there's, I believe that HHS, the entity that and CMS that may administer Medicare, have moved towards solidifying the telehealth changes,
Right.
such that previously, pre-pandemic, the patient had to be at a certain site in order to be able to be reimbursed, for the clinician to be reimbursed. They had to be in a doctor's office, et cetera. The pandemic change got rid of that. Patients can be in their home, and the clinician can be reimbursed still for telehealth delivered to the patient in the home. That change, as far as I can tell, has been codified. It's going to continue. So some of these changes will continue, but unfortunately, there have also been attempts to rein in the telehealth expansion because people are afraid, or legislatures are afraid, that there's a lot of fraud. They believe that fraud is much easier to commit in a telehealth setting. And so there's a competing effort to tamp down the liberalizations that went on. One of those is that upon expiration of the federal health emergency, telehealth Medicare patients are supposed to have one face-to-face session every 6 months in order to be able to use telehealth. A lot of controversy about that, and we'll see what happens. But so there's tensions both ways, to preserve the liberalizations and also to try to pare them back down again.
Yeah, I think it's pretty clear that the value of telehealth has been established, but this is a balancing act. I don't think that's going to go away, but frequently you'll get people that say, well, I can practice using Zoom or some video telecommunication, but I can't use my telephone. Those are areas that are still being carefully defined, but I think that it's been established that it is effective, and it really allows places that are challenged for mental health services to have access to mental health treatment.
Mm-hmm. Yeah, and to your last point too, Joe, and about the one time a visit per 6 months for Medicare, I believe that is going to that has not yet been able to be taken out of the new bill, and that will be a requirement. Although it's my understanding there will be some allowance for some exceptions to that. So you know, basically, we're going to have to watch and see what that information is as that gets notified down the line. But really important to pay attention to the changes that are happening. So
right.
Okay, so the next question then, it says, I'm interested in the legal and ethical differences in confidentiality and disclosure of mental health and neuropsychological information in private practice settings as compared to medical contexts, such as university medical neuropsychological providers. Does a client or a patient have the right to request that reports not be posted on medical servers? And Jeff, do you want to start with that one?
Yeah, I mean, I'm not the lawyer Joe is, but I think that it depends upon the operational requirements of the setting. If the records of if the custodian of the record is the hospital, then those pieces of information are stored at the hospital, and the hospital is the custodian of the record. I don't think that the patient loses control of that information. It's just where the information is going to be stored. I think that it would really depend upon the administrative requirements of the facility that you're in. Neuropsychologists and other types of specialties, I won't pick just on neuropsychology, want to keep the psychological information close to them and not have it go anywhere else. Well, the sad truth is it is PHI. And so in a private practice, you manage it one way. And if you're working in a hospital setting, or if you're working in a clinic setting, it's dealt with in another way. And it's discoverable based upon the state laws. And restricting access to it may not be successful.
Joe, any other?
I think this question, I think, touches on the open notes rule, which is a new rule that is being put in place for practitioners and hospitals that use what's called an interoperable electronic health record system. And if a clinician or a hospital has that, it's required to give patients immediate access to their medical record so that they can instantly dial in or connect to the server of the clinician or the hospital and see the notes and the records and reports and et cetera. Where things have gotten a little controversial is the report, a neuropsych report or a clinical psychological evaluation report clearly would be available to the patient. The question is, are the underlying data and the underlying materials, is that also included in the open notes rule that's supposed to give clients sort of unfettered access? And that there's some, like any new rule, there's a lot of hammering out of how it's going to be applied. But a good case can be made that no, there's some things that should not be readily and immediately available to patients, either because it implicates test security or because it may be shocking and disturbing to clients who have not had a chance to receive the information and have it processed through communication with the clinician. So there are exceptions that prevent certain materials from being made available. And it's important to know that this open notes rule at this point essentially really applies only if you're using an interoperable EHR. But fairly soon down the line, it looks like it's going to be any EHR that is being used may have to have this capacity. So it's on the horizon for independent practitioners. And it's something to pay attention to. Again, the open notes rule. If you have questions about it, feel free to call us for a consultation.
Right. And so I am noticing the time. I'm going to try to pick up our pace just a little bit here so we can squeeze in as many of these as possible. Joe, I'm going to toss two to you right away because I think these hopefully are going to be pretty quick. But one, can you form an LLC with only one person?
Yes. Well, it depends on your state. Many states allow what are called single member LLCs. A few states don't. So you need to check with your state authority. But I happen to operate a single member LLC. You get the benefits of the LLC, which is the corporate veil, and taxes for a single member LLC are your regular 1040 Schedule C taxes. So it's kind of neat, works pretty well. And so it could be a good option for you, but you need to check, does my state allow single member LLCs?
Great. And second one also to you, Joe, just because it's on the business structure, are meeting notes, yearly meetings required as a PLLC if I am the sole person in the PLLC?
Again, it depends on state rules, but typically, yes, you may be the only member and your meeting may be with yourself. So you may sit there and jot down some notes and that's your meeting. But, like many legal requirements, it's a formality and it may not have much intrinsic value, but just doing it shows that you're in compliance with the spirit of the law. So yes, you may end up having a solo meeting with yourself.
Thank you. All right, Jeff, I'll toss this one to you. How much narrative should be in a session progress note? Is a checklist enough?
There are no concrete rules about what is adequate. It's a standard of practice issue. First thing is HIPAA doesn't recognize process notes. HIPAA has two records. One of it is the protected, the content record itself, and the second is the psychotherapy note. And there are various models for record keeping. You're measured by the adequacy of your record keeping. Sometimes you can write too much, and sometimes you can write not enough. It is really a kind of a fluid situation, and record keeping, we have always taught, is a dynamic. If you have somebody that comes in is really not dealing with extremely difficult issues, it's one of many psychotherapy sessions. You're talking about the general things you've talked about before. The note would be relatively short. If you're having a patient who's coming in and having thoughts of committing homicidal acts and is suicidally depressed and whatever, the note for that individual should be substantially large. Under HIPAA, the note is defined as any record that, and I think I remember these, it's a diagnosis, treatment plan, prognosis, progress to date, mental status. All those are part of the record to which the client has access. And that is so some people will say that they're going to try and put information in a separate note and to hide it. And some states allow people to have access to psychotherapy notes and others don't. But then they all require that you turn it over to someone else if the client requests that you do it. So to go back to the genesis of the question, it's really more keeping an adequate note. If the check boxes let you know they're depressed and their thinking is confused and their eye contact is poor, those are fine. That's not a problem. But I think just a series of check boxes arguably may not be enough, because what's the treatment plan and what's the prognosis and those kinds of things, which good record keeping requires.
Yeah, and I'll add to that, Jeff, it also, what goes into your notes will depend also in part on whether or not you're an in-network practitioner for insurance companies, because if you are in network, the various insurance companies are also going to have very clear requirements for what you have, like minimum requirements for what you have.
That's a great point. That's a great point. And they do audit. So I know people think that they don't, but we get calls all the time about insurance companies auditing, and they have a right to audit for a variety of reasons. But it's better to remember that they do have the authority to audit, and you as a contracted provider in that network have a compliance responsibility to what they're expecting the record to show.
Right. Thank you. Okay, so I'm going to jump around a little bit here. Joe, this one is for you. I'm an independent practitioner, but I rent office space, telephone, use of secretary from another psychologist. I do not use his name in my business, and I have a business name that's different. Am I in an apparent partnership? And I'm tossing this to you because we're getting a lot of questions about this. I think you can explicate and clarify.
Yeah, no, I think it's unlikely. The key rule would be, would a service recipient, a patient, an examinee, a client, would they perceive in total from all the indicia that exist in your office and in your signage and your paperwork, would they reasonably conclude that you're in business with other people? That's really the test. So the fact that you rent or pay for some service, administrative service, that doesn't create any particular reason for a consumer to believe that you're in business with that other person. It's not something they would know about or normally be told. So those kinds of behind the scenes arrangements that you work out with your landlord, those are okay. It's the presentation to the public that's the key issue in determining whether you've inadvertently created an apparent partnership.
Yeah, put it in your informed consent. Put it as the first line in your informed consent that I'm an independent practitioner. And the client signs that. It clearly pumps a lot of water for proving that you did convey that you were in fact an independent practitioner. You go like, well, here's the form. And they signed the form, and the first line says, I'm an independent practitioner.
Right, great. Okay, so here's another one, Jeff, I'll toss this to you. Says, I belong to a consultation group that meets monthly to discuss cases. No patient names are shared. How does this impact confidentiality and HIPAA rules? Also, MDs routinely exchange information with each other without a release of information and often expect it from me. Can I share info with a patient's MD without obtaining written consent from the patient?
Yeah, this is not an uncommon question, actually, and HIPAA does allow for the exchange of information for treatment plans between providers, which is why MDs can do that. But we believe that the protective approach to this is that you should get an authorization to release information to other healthcare providers. It is just a safer course of action. I know people say, well, my cardiologist talks to my dermatologist without any authorization, and there's an argument that HIPAA allows that. But psychotherapy is a unique private event, and I think that we advise that you should get an authorization. Consultation groups are very important, but they're important to keep them called consultation groups versus supervision. Consultation does not have vicarious liability. So you can talk about cases in consultation groups. You can share the nature of a patient's or a client's difficulties in those groups, sanitizing that information so there's no identifying information, and that is not a breach of confidentiality. In fact, it's one of the three legs of our risk management model, which is consultation. The more you talk to other people, the more you've created a standard of practice argument that your behavior is consistent with the standard of care. What's important is to call it consultation.
Right. Yes. And I think that's a great point, Jeff, because I get calls from folks and talk with clinicians who are sharing identifying information in consultation groups, and that's the problem. But if you're making it, like you say, sanitized, that is safer. And just to also underscore, I think we've covered this, but our risk management model does recommend, in terms of strategies, informed consent, which we've talked about here, good documentation, and of course, a low threshold for consultation. And also, I think we've recently added in there good self-care as well. So I just want to be sure we fit that in the end.